Hello everybody, welcome back. We're heading into our fifth video, and as promised last time, we're going to pick up with the General Welfare Clause. Just as a point of clarification though, from the last video, there was apparently a little bit of a confusion. When I was saying that the Supreme Court may give its own interpretation or do what it will with the laws that come before it. The point that I'm trying to make that was that may have been omitted was that as a more technical matter, it's strictly the executive power or that is the power of the president to veto legislation. It is only within his power to deem an act that is legitimately passed by Congress null and void. The Supreme Court does not. So all that I was trying to say at that point is it is the sole power of the executive to actually deem an act null and void. That is, he vetoes it. Actually, it's from the Latin veto, meaning I forbid. The Supreme Court cannot deem an act null and void. They can say that they believe it's unconstitutional, but even at that point, properly speaking, that law is still on the books. It is just that particular case or controversy put before them where they can say, we don't believe that this act is constitutional, and therefore the person being tried or persons being tried cannot be convicted underneath it. And that is really the extent of their jurisdiction. Remember, we can argue. That almost harkens back to that excerpt from the Federalist Papers that I read from Madison, where I'm sorry, it was from Hamilton, where he said that the courts have neither force nor will, but merely judgment. So almost. It can be said really that the Supreme Court, when we have laws brought before it for review, they're, in a sense, really all they can do is give their opinion on it. We're asking their opinion, the opinion of the highest court in the land. Do you believe this is constitutional? Whether they say yes or no is irrelevant to the actual existence of the law. If they deem something unconstitutional, that does not mean that it is no longer a law. It is still a law, but it'll be very hard to convict anybody underneath it. Generally, you'd have to repass the law by Congress again and have it signed by a president, and then they'll try and send that same law again through up to the courts, eventually hopefully getting them to rule in favor of it, assuming that it is in fact a constitutional measure. That's all I was trying to say with that. If there's any more confusion, please, by all means, you can email me at nathangniewek@gmail.com, and I'll try and sift through those and bring up any points of clarification that anybody might require. Now, with that behind us, I can finally get back to the point at hand. We were going to discuss the General Welfare Clause of the Constitution. In its full context from the Constitution, it reads, quote, "The Congress shall have the power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States. But all duties, imposts, and excises shall be uniform throughout the United States," end quote. As a side note, the provision that all duties, imposts, excises shall be uniform throughout the United States has been done away with via Amendment 16. That is the one that allowed for the income tax. Whether or not that amendment was ever legitimately ratified, however, is actually still a point of contention. However, that's neither here nor there in terms of actually defining what the rest of this term of art means. So we can I can continue onward from there. The first thing to notice about this often misunderstood phrase is that it does not grant the power to legislate for the common defense and general welfare, but rather it permits Congress to tax for that purpose. This is, in fact, the taxing clause and nothing more. The sentence structure alone is sufficient evidence that this is actually the case, and to interpret the clause as meaning that Congress may do anything so long as it considers the measure to be for the common defense and general welfare renders every other enumerated power from Article 1, Section 8 to be superfluous or moot. It's little wonder that, since he was of Federalist mindset, Hamilton tried to push for a more lax interpretation of the clause. However, given that such an interpretation is inherently contrary to the structure and nature of the rest of the Constitution, Hamilton's view on this matter cannot be considered valid. As an interesting historical side note, Gouverneur Morris, the main penman for the Committee of Style, which was commissioned to formalize the content of the Constitution after the Federal Convention in 1787, actually tried to ensure that the General Welfare Clause was interpreted as a distinct grant of power in such a way that he could not be accused of altering the actual text. That is, he tried to plant a semicolon between to lay excises and to pay the debts and provide for the common defense and general welfare of the United States, so instead of a comma. See, cleverly, he could have said, no, I didn't alter what the convention decided. I put different punctuation in there, so it was actually pretty clever. The semicolon, however, was in fact noticed by those who had attended the convention, and when it was brought to the attention of the other delegates, it was finally and definitively replaced with a comma. And this goes to show that the men at the convention did indeed intend that this entire provision be interpreted as a single grant of power to Congress. It's actually kind of interesting to be able to go back and look at the history of it. It just stands to reason again that this is not a unique grant of power for them to legislate for the common defense and general welfare, but rather only to tax for it. Continuing onward, context is particularly important in finding the appropriate definition of this clause. First, we have to note that the taxing power is the first provision of Article 1, Section 8 of the Constitution, which consists of the enumerated powers of Congress. They are the only explicitly listed powers allotted to Congress unless a constitutional amendment is passed giving it more. Second, the language is drawn from the third section of the Articles of Confederation, which read, quote, "The said states hereby severally enter into a firm league of friendship with each other for their common defense, the security of their liberties, and their mutual and general welfare, binding themselves to assist each other," end quote. Now, one can draw out of this segment of the Articles that the states were to act in solidarity to ensure each other's protection and well-being, and thus all the states in the aggregate. With this information in mind, Forrest MacDonald, the historian that I quoted last time, his conclusion seems to follow that, quote, "The phraseology of this clause was understood as prohibiting the expenditure of money for such internal improvements as roads and canals, since those of necessity promote the particular welfare of specific states rather than the general welfare," end quote. However, what's stated above is a prohibition. That is, it says that it tells what the clause does not mean or what Congress may not do. What may it do in light of this provision? Having debunked Hamilton as a reliable source in this matter, it would probably be best to turn once again to James Madison. One of the most prominent concerns he had to address just prior to the Constitution's ratification concerned this very clause. Now, many feared that it served as an unlimited commission to exercise every power which would be alleged to be for the common defense and general welfare. Madison responded as follows, and this is an excerpt taken from Federalist number 41, where he says, quote, But what color can this objection have when a specification of the objects alluded to by these general terms immediately follows, and is not even separated by a longer pause than a semicolon? If the different parts of the same instrument ought to be so expounded as to give meaning to every part which will bear it, shall one part of the same sentence be excluded altogether from a share in the meaning, and shall the more doubtful and indefinite terms be retained in their full extent, and the clear and precise expressions be denied any significance whatsoever? For what purpose could the enumeration of particular powers be inserted if these and all others were meant to be included in the preceding general power? Nothing is more natural or common than first to use a general phrase and then to explain and qualify it by a recital of particulars. But the idea of the enumeration of particulars, which neither explain nor qualify the general meaning and can have no other effect than to confound and mislead, is an absurdity which, as we are reduced to the dilemma of charging either the authors of the objection or on the authors of the Constitution, we must take the liberty of supposing had not its origin in the latter." End quote. Now, therefore, as used in the Constitution, the term common defense and general welfare refers to the things that the Congress is already permitted by the Constitution, specifically Article 1, Section 8, to do. Now, from this, one may also deduce the meaning of the clause as a whole to mean that, and this is me sort of summing up, we can understand this clause to mean that Congress may lay and collect taxes of various kinds to pay the debts of the United States, and also may do the same to carry out and perform those enumerated duties, rights, and powers which the Constitution permits Congress to do. Now, this, in a sense, also sort of boils down to the idea of a federalist system of government, here federalist with a small f. The general rule for determining whether or not the federal government may do something is to say no. If Congress were to ask, may I pass this bill, may I appropriate this, do that, the usual default answer for them is no, not unless you can find a grant of power in the Constitution which says yes, you may. The general rule on the flip side of that coin for the states, and this is touched on by the 10th Amendment of the United States in the Bill of Rights, the states, on the other hand, they have it in the opposite. If a state has a question about whether or not it can do something, the general rule of thumb is you can say yes, unless you find a restriction of power within the Constitution. So the default answer for can I do this for Congress and the rest of the federal government is no. The default answer for the states question, may I do this, is yes. And then we have to look for the exceptions. Now that actually didn't take very long to do, so I think we can move on to the next major constitutional clause that merits closer examination. That is the Commerce Clause. And this is another one of those colossal constitutional train wrecks of our time. In the full text, the clause states that Congress shall have the power, quote, to regulate commerce with foreign nations and among the several states and with the Indian tribes, end quote. Now, first, to be perfectly fair, one should note that at the time of the adoption of the Constitution, the term commerce was not really fully defined yet as a legal term. Little mention of it was made in Blexton or any of the other major authorities to whom the founders looked for guidance. Thus, the best thing we can really do is to attempt to define commerce and what it means to regulate it. We have to study the context and the writings of those who crafted the terminology itself. Now, first, one should try to build up from what is the more common notion of the word. The first thing that comes to mind when one thinks commerce is either something close to all business activity aimed at gaining a profit, or something nearly equivalent to trade. And the latter may not be too far off from what the founders believed commerce to mean. The term is used many times over in the Federalist Papers and Madison's notes on the Federal Convention. And in no instance does commerce seem to mean anything more than the simpler substitutions just suggested. Now, I think it's fair that the Commerce Clause really being so complex, even though it is such a small and yet so very dense term of art, I do believe that its explanation would warrant a video in and of itself, because it really would not be a good idea to try and cram it into this one and make this one unfathomably long. So if it's all right with everybody, I'm going to hold off on the Commerce Clause going into it into its deepest depths until next time. But I figured I'd give you a taste for what it is and exactly what we're going to do when we begin next time. So I know this video is actually a little shorter than usual, but still, I think we accomplished what we were going to do, and I guess I can just wait to see you next time. So in the meantime, take care, and God bless. Bye.